Hello and welcome. My name is Rusty Lane. I'm the Managing Senior Articles Editor for the Journal of International Comparative Law here at the University of Notre Dame's Law School. Today I have the privilege of introducing our next speaker. Ms. Rita Heims is the International Association of Privacy Professionals General Counsel and Privacy Officer. Prior to joining IAPP as its first research director in 2015, Ms. Heims was a law professor and academic dean at the University of Maine School of Law, where she directed the Center for Law and Innovation and developed the nation's first Privacy Pathways program. She also worked in private practice with law firms in Seattle, Boulder, and in Portland, Maine. Please join me in welcoming our next speaker, Ms. Rita Heims.
All right, thank you very much for having me. Good afternoon, good morning, good evening, wherever you may be. As the kind introduction said, my name is Rita Heimes. I work for the International Association of Privacy Professionals, and I have a couple of hats there. I am the General Counsel and the Chief Privacy Officer. The IAPP, for those of you who may not be familiar, is a nonprofit professional membership association. We are under a 501c6 of the Internal Revenue Code. We're based out of Portsmouth, New Hampshire, with an office in Brussels, Belgium. We have over 200 employees and almost 70,000 members globally. So I have some slides that I'm going to share with you today, and I may beg your indulgence while I get those going. How are we doing on slide sharing? Does that look good? Great. Okay. So just a little bit about the IAPP, and I tell you this mostly for those law students out there who may be unfamiliar with this association. Most students have heard of the American Bar Association, wonderful organization. We are a similar kind of association in that we have members and we have members globally. So these are people who, generally speaking, are either outside counsel and law firms representing companies who are interested in complying with global privacy laws. They may be in-house privacy professionals, people like me who are privacy officers, or all the way down to people who have titles like privacy analysts. There are people who are privacy engineers who work in the product development department, working to do privacy by design. So privacy has certainly invaded all aspects of many organizations, and a number of those people achieve IAPP certifications and become members of the IAPP. We are a policy neutral organization. We don't advocate for laws one way or the other. Our mission really is to promote the privacy pro by providing information and guidance and tools for them to use in doing their jobs. And also bringing people together. Normally we try to do that in person, but lately we've been having, like this, a lot of virtual events for people to get together and talk about how to do the job of privacy as best they can. So as you can imagine, it is a heady time to be a privacy association. The EU's GDPR, the General Data Protection Regulation, which came into force in May of 2018, really has just been a game changer in the privacy and data protection world. And there have been many laws passed throughout the world now that are mimicking most of the protections of the GDPR. Places like Brazil, of course, the California Consumer Privacy Act recently passed and recently amended in California are just two examples. And as many of you know who study this field, these laws are largely based off the GDPR and the principles of the GDPR. So I just, at the beginning of my remarks, want to give you some context. One is I was told that there may be less than perfect familiarity with the status of the Screms 2 decision, all that led up to it and what's come since. So I'm going to assume that a little background is acceptable. I hope I don't bore you. And also that you should know that I am a privacy pro. I help a company work to comply with privacy regulations. So I think about the law and I talk about it in a very practical way. What does it mean to an entity that is attempting to comply? So if you get that sense from my remarks, it's because that's just my perspective. I don't come at this as an academic. I don't come at this with a policy mind. That said, I'm happy to answer any questions as I can as we get through the remarks. And I have seen some of them that have come through the Google Doc. All right, this is a story, as many of you know, about surveillance and surveillance law, but it's also really very much a story about people. And in particular, for those of you who are law students, there's a large role that was played in this story by a young legal advocate who has personally made life very difficult for governments and regulators and businesses alike in his steadfast efforts to challenge the data security and data transfers from the US to the EU. But first, a little background. So the GDPR, as those of you probably in the audience know already, has as one of its primary objectives to allow the free flow of personal data among member states of the European Union. But another one of its primary goals is to ensure the levels of protection of the rights and freedoms of the people of the EU are extended even when their data leave the EU. Accordingly, under Article 3 of the GDPR, any entity that does business with EU residents is obliged to comply with the GDPR in handling their personal data. As well, under Article 45, there are restrictions on the export of that data to outside of the European Union. There are methods by which one can export personal data out of the European Union, but they are limited. And so I've outlined some of them here. For example, data may be exported out of the European Union to a country that ensures an adequate level of protection for the personal data as determined by the European Commission. This is essentially a country like Canada, for example, and the UK just recently, as of today or yesterday, that have achieved adequacy status in the eyes of the European Commission. In the absence of an adequacy determination of the jurisdiction to which the data is going, the entity itself, the controller or the processor transferring the data, may provide safeguards, appropriate safeguards, provided that there are enforceable data subject rights and effective legal remedies available to the data subjects. And if that's not feasible, then in the absence of either of those things, the controller or processor can attempt to fit the data transfer into one of several derogations for the specific situations of the transfer as set out in the regulation. But for purposes of today's discussion, we're mostly focusing on adequacy determinations and the more formal safeguard approach. I gave away that burst of excitement here. So I just wanted to go back to adequacy really quickly. The US has never sought adequacy from the EU Commission as a country, as a jurisdiction as a whole. It does not have, as you all know, a comprehensive consumer privacy law that looks anything like the GDPR. We have HIPAA, we have the Gramm-Leach-Bliley Act, we have COPA, the Child Online Privacy Protection Act, and several other laws like that, FERPA. Section 5 of the Federal Trade Commission Act gives the authority to the FTC to enforce against unfair and deceptive trade practices. And of course, there are a number and an increasing number of laws at the state level that provide consumers with privacy rights. But as of now, no federal law that provides the comprehensive level of privacy and data protection rights that are offered under the GDPR. So as a workaround to jurisdictional adequacy, and in order to help US businesses continue to transfer data out of the EU, the US Department of Commerce worked with the EU Commission to develop what was known as the Safe Harbor Mechanism. This system encouraged companies to self-certify to a set of principles. They certified this to the Federal Trade Commission and participated voluntarily in the Safe Harbor program. If, however, they should at any time violate these principles, violate their promises to the Federal Trade Commission, the FTC now had a basis for going after and enforcing the law against those individual companies for failing to abide by their commitment to these principles, or alternatively, for lying about their participation in the Privacy Shield program or Safe Harbor program had they not truly been participating. So this was a quintessentially American-style program, voluntary participation by enterprises and enforcement upon breach of those commitments by the FTC against the enterprise. And it wasn't always a super popular mechanism in the EU. Some of the data protection authorities at the levels of the member states sort of grumbled about the validity of this adequacy mechanism. But it wasn't really until, here's the reveal, this man provided his disclosures in 2013 that we finally saw the stake in the heart, if you will, of the Safe Harbor program. This is Edward Snowden, of course, and he revealed that the National Security Agency was engaged in extensive surveillance of U.S. citizens' electronic communications, emails, text messages, and the like. This surveillance scheme was carried out with the cooperation from numerous other governments in the world, as well as with commercial entities in the United States via upstream surveillance, such as with electronic communication services like AT&T, as well as via the PRISM program, including companies like Microsoft, Facebook, Apple, Google, and others. And as The Guardian, which broke the story, explained in 2013, and I quote, "Cell phones, laptops, Facebook, Skype, chat rooms all allowed the NSA to build what it calls a pattern of life, a detailed profile of a target and anyone associated with them. And the number of people caught up in this dragnet can be huge. You don't need to be talking to a terror suspect to have your communications data analyzed by the NSA. The agency is allowed to travel 3 hops from its target, who could be people who talk to people who talk to people who talk to you." End quote. So the EU Commission took note of these updates, and it started to renegotiate the Safe Harbor program with the US Department of Commerce, again, engaging in this bilateral political process. But some other people also took note of it, including this young Facebook user. So this is Maximilian Schrems. He's an Austrian, and while he was studying for his law degree, attended school, I believe it might have been at Santa Clara, but it was somewhere in Silicon Valley. And legend has it that he was sitting in a lecture hall listening to a Facebook privacy attorney talk about data issues at Facebook, and he became sufficiently agitated by what he learned in that lecture to decide to take matters into his own hands. So upon returning to the European Union, Mr. Schrems lodged a complaint with the Irish Data Protection Commission against Facebook Ireland, requesting that the termination of any transfers of his personal data by Facebook to the United States. And he claimed that Facebook Ireland, which was the data controller for the Facebook US with regard to EU users' data, that Facebook Ireland could no longer rely, as it had been, on the Safe Harbor framework to legitimize the transfers of his data to the US. Because of the wide access, it is now known that the US intelligence entities had to such data, as revealed by Snowden. So the matter ultimately made its way up to the Court of Justice of the European Union, the CJEU, which in October of 2015 issued its ruling, declared the Safe Harbor adequacy decision invalid. So the parties had to start over, renegotiating a bilateral agreement that would allow commercial entities in the United States to still do business with European Union customers and transfer data to the EU under some replacement adequacy regime. So after more than 2 years of negotiation and with input from the Article 29 Working Party, we had, in July of 2016, the US Privacy Shield program, also administered by the Federal Trade Commission. Again, a similar program in terms of its voluntary participation by commercial enterprises, and basing itself on these very important principles. And these are, again, to those of you familiar with the FIPS and the OECD principles that have been fundamental to comprehensive privacy laws like the GDPR. These are the principles that are foundational to the Privacy Shield program and those who participate in the program. So notice and transparency to individuals, choice and opportunity to participate in the data collection process and the processing of the data, accountability for that data when it's transferred to another entity. These are the data processors that often house the data, or other vendors. Security of the data, of course, integrity, and limiting the purpose of its collection and use to only what is necessary. Rights of access by the data subjects, and rights of recourse and enforcement, another liability for failure to abide by these principles. So again, this is just the shorthand. I only have 30 minutes of what the Privacy Shield program looks like, and participation, I should say, looked like, and same with participation. So I need to take a minute here, because Privacy Shield is only one mechanism that was in place for the transfer of data from the EU to the US and to other places in the world. The GDPR sets out other mechanisms. A popular one among organizations of a sufficient size are binding corporate rules. These are typically used, if at all, by multinational organizations. And they require extensive drafting and approval, and ultimately they have to be signed off upon by a data protection authority. So they're not for everyone, but if you have them and you have them approved by a DPA, they're often an excellent mechanism. Article 40 calls for codes of conduct that are appropriate to the industry. Article 42 calls for certification mechanisms that you can certify to participating in certain principles, but both of these require an oversight entity to make sure that the certifying bodies or the participants in the codes of conduct live up to their obligations. And so, even 2.5 years after implementation of the GDPR, these are relatively immature programs and are not as well developed as to be widely accessible to US and other organizations that are not in the EU. There are other things called derogations. They are for specific situations, things like explicit consent from the data subject to take their data out of the EU, fulfillment of a contract for services, for example, with the data subject, provided that it's a limited and one-time affair, public interest or vital interest of the data subject, or for purposes of a legal claim. Those kinds of situations are known as derogations. And again, they're to be used in a limited way and usually on a case-by-case basis. The most popular non-adequacy form of extracting data from the EU, of course, are standard contractual clauses, also known as model clauses. We did a survey not too long ago at the IAPP in which we asked companies who participated in the survey if they were subject to GDPR, which mechanism they used, and almost 9 out of 10 of them used standard contractual clauses. It is by far the most popular mechanism for data transfers that there is, and they are pre-written, non-negotiable set of contractual clauses issued by the EU Commission. And they come in a couple of flavors, but the most popular ones are controller to controller or controller to processor model clauses. In essence, both parties agree to those same principles. They agree to abide by those principles or the laws of the jurisdiction in which the data subject is housed, and they contain all the enforcement mechanisms within them that a data subject would need should they feel as though their rights are being violated. All right, so that is an overview of where things stand in terms of data transfers from the EU. But of course, we are not done with Mr. Schrems. So having vanquished Safe Harbor successfully, Mr. Schrems established his own company called None of Your Business, NOYB, and you can find them at noyb.eu. It's a nonprofit activist organization empowered to bring claims on behalf of data subjects in Europe. And these are things that the GDPR anticipates will happen to make it easier to enforce personal rights under the law. So he once again challenged the legitimacy of Facebook Ireland's transfer of personal data from the EU to the US. And this time, he not only called into question the adequacy regime, the privacy shield regime, but also standard contractual clauses, model clauses. The primary challenge of these mechanisms in his complaint is, of course, the US government's continued authority to conduct electronic surveillance under Section 702 of the Foreign Intelligence Surveillance Act and Executive Order 12333. this notion, of course, is that U.S. companies may promise under model clauses to provide privacy rights, but if they can just be overridden by a government surveillance order, a secret order at that, then what good is the paper that these clauses are written on? So again, Mr. Screms is successful, and in July of 2020, the ruling, commonly known as Schrems 2, found that the Privacy Shield framework was invalid due to the ongoing ability of the U.S. government to conduct surveillance under 702 orders. And standard contractual clauses, while not invalidated, so that's the good news for those who rely upon them, were under question. And now to use standard contractual clauses, entities have to do a case-by-case analysis to determine whether the data importers to whom they're sending the data have adequate protections in place to ensure that the government can't conduct surveillance of the data subjects that are in the data transfer pool. All right, so now what do we do, right? What happens post-Schrems 2? What are companies, entities doing? What are governments doing to react to the fact that this adequacy regime is gone from the United States and is swept out from under the 5,000 or so companies that had relied upon it, and that standard clauses are allowed but shaky, but maybe necessary but not quite sufficient. So what do we do now? Data flows obviously did not stop, right? They continued exactly apace for the most part that they did before the Schrems 2 ruling. We asked again in a survey, all right, so now what are you going to do? Those of you who relied on model clauses or Privacy Shield, are you planning to switch your transfer mechanisms? And a number of them said yes, they were going to look at new mechanisms. So more than half, 62%, said they were going to switch transfer mechanisms. This is a massive impact on business, and it takes a long time. It's not something that you can turn the next day and do a different transfer mechanism. You have to assess and think about it and choose the one that is going to be most effective and least likely to challenge, and of course provide the most rights to your data subjects. Model clauses are still very popular, perhaps slightly less so than they were post or pre-Schrems 2. But now we're going to be seeing that companies are doing something a little bit extra than just signing the clauses as they are written. And indeed, there's been a fair amount of guidance that has finally come out in recent weeks and months from Europe in an attempt to help organizations decide what to do now. Adequacy is still very, very challenging. The EU has only 12 adequacy determinations, I suppose 13 if you add in the hot news about UK achieving adequacy, at least preliminary adequacy. That means the rest of the world, it's not one of the favored 12 or 13, does not have adequacy. So there have to be other mechanisms or it will be impossible, presumably, to do business in Europe. Companies have responded by taking a look at their data flows again. They've gone back to some of the early analyses that have always been recommended of data companies, but now they're getting a formal title. So you've heard of privacy impact assessments. Now we have transfer impact assessments. So we are seeing companies who are deciding on a very official, of course, Max Schrems is happy to provide you with a form. And these are designed to determine the extent to which data may be subject to surveillance by the entity that's importing the data. They're also designed to tease out what technical standards are in place to safeguard the data. So the European Data Protection Board in its recent guidance emphasized that while contractual promises are still important, I promise to safeguard the data, I promise that I will have organizational measures in place to help ensure that data subjects have all the rights under the GDPR in the US, for example, that they have in Europe. Those contractual requirements are terrific. What the EDPB really wants to see is encryption. It wants to see that the data is encrypted in transit, that it's encrypted at storage, that it is incredibly difficult, if not impossible, for those private facts to be surveilled on their way across the Atlantic. And so I think that's the highlight here, is the companies right now, as we speak, are busily conducting their own transfer impact assessments and revising their standard contractual clauses to add in additional safeguards. The recommended additional safeguards that are contractual in nature are things such as, I promise that I'm not subject to FISA 702 as an entity. I'm not an electronic communication provider. I do not, I'm not subject to upstream surveillance requests from the federal government. I just don't fall under FISA 702. And a huge number of entities in the US do not fall under FISA 702. So that's one thing. If I should ever get a request from the government to turn over your data, I will tell you that I have such a request, and I will fight to resist that request on your behalf. These are all the proposed promised language that is starting to be added to model clauses. So the other thing that's happening, of course, is that people are sharpening their pencils and going back to the drawing board. The EU Commission and the US Department of Commerce are absolutely going to work on coming up with another adequacy framework to replace Privacy Shield. How long this will take, I don't know. It was certainly a significant set of questioning at the confirmation hearings that we've seen recently for the Biden administration. This is a major issue for international trade between the EU and the US, and it's not something that Congress or the Biden administration can simply ignore. So, so stay tuned. This space will definitely continue to evolve. And yes, there will be organizations that are caught without having adequate mechanisms in place. But we'll see how long it takes for the parties to negotiate a rescue in that regard. So I see that I have just a few minutes left, and I wanted to try to turn to the questions that had come in before I started my remarks. And they had to do with the future of privacy law in the US, and whether any changes in US privacy law might create a satisfactory regime to get around US surveillance concerns, to pacify our European colleagues. And I think my prediction, which you shouldn't bank on too much, is that the mechanism that will best lay to rest the fears of our European friends would be a comprehensive federal privacy legislation that provides US citizens and residents the same level of data protection rights that are guaranteed those in the EU. What the UK did in Brexit was it essentially adopted GDPR and pasted it into UK law. And that has been very helpful in it achieving adequacy from the EU Commission. So that would be necessary for the EU to be able to slide into adequacy at that level. Certainly, I believe that would go a long way to allowing commercial data transfers. Max Schrems just tweeted about the UK adequacy decision that it's great news for commercial transfers, but it doesn't make anything any less concerning with regard to surveillance, because as we all know, the UK is a member of Five Eyes. There's still government surveillance happening among EU governments and data exchanges happening at a level. So there may be a different regime for government surveillance transfers and one for commercial transfers, even with a GDPR style comprehensive federal law in the US. Meanwhile, remedies for Europeans who are concerned about the state of their data transfers to the US principally will rely with complaints at their local data protection authority. The local data protection authorities are seeing plenty of these days. They are quite overwhelmed, actually, with the number of complaints being filed under the GDPR, because it does provide for a private right of action. So I think this will shake out sort of slowly and over time, and the presence of a comprehensive US law will raise the level of data protection quickly enough on the US side that the pain will be lower, I think, than if we're always simply waiting for an enforcement action in the EU to try to get us as US companies to provide the same level of rights to our customers in the US that are provided to data subjects in the EU. So let me take a look at my time. I have 2:44. And I will quickly stop sharing and see if I can find any additional, I'll try to stop sharing, any additional questions in the chat. Oh, I think the one last question that I'll try to squeeze in is what's different in the pandemic. And I did appreciate the comments that were made in the last session about how what the pandemic has done is just created even more online behavior than ever before, more recording of content, more participation in online teaching and forums. And so the amount of data about us is more than ever. This recording will probably be available somewhere, and where it wouldn't have been had I come to Notre Dame myself, which I would have loved to do. So I think that the pandemic has raised health-related privacy issues at the level of employers that they didn't have to grapple with before. But I don't see it as a game changer in terms of federal privacy legislation and a bilateral adequacy determination. I think that's coming from politics. It tends to be a bipartisan issue. The real sticklers here are whether or not a federal law will be preemptive of the state laws that are coming online faster than we can write about them, and whether or not there will be a private right of action, which is not a bipartisan issue, as you can imagine. So those are the huge issues to look for in comprehensive privacy laws coming up. And by the way, I just want to encourage any of you who are interested in the field to reach out to me personally at rheims@iepp.org, or link in with me if you'd like. It's a great profession. It's very challenging, never a dull moment, and a lot of work for young privacy lawyers to be had. So I encourage you to think about that as a career path. And thanks for having me.